Okay, good afternoon, everybody. Again, my name is Peter Neufeld. You've probably seen me before if you've attended any of these prior Lunch and Learn seminars. I'm a partner at the firm Wagner Sidlofsky LLP. I'm here with my co-chair for the Lunch and Learn series, Professor David Friedman. He will be talking about the substantive issues today because he will be speaking with James Dunphy about today's topic. Today's topic is life insurance proceeds, security under the Family Law Act, and dependent support. A paper was prepared by Professor David Friedman in advance of today's seminar, and a link to that can be found in the Zoom chat. As I indicated before, a certificate of attendance will also be posted in the Zoom chat momentarily for you to download. A few housekeeping notes as usual, just common sense. Make sure to have your microphones muted at all times when you're not speaking. If you do have a question, feel free to chime in, but then mute yourself after you've asked that question. Please also note, you may have seen a pop-up that this seminar will be recorded. Okay, as I indicated, we've got two presenters today, David Friedman and James Dunphy. James is a partner at Wagner Sidlofsky. He practices exclusively in the areas of estate litigation, where he is certified as a trust and estates practitioner, as well as in the commercial litigation branch of the firm. David is a graduate of Osgoode Hall Law School, Oxford, and Cambridge University. In addition to his practice, he is a tenured professor at the Faculty of Law at Queen's University and the author of a number of publications on trust law, wills and estates, guardianship, and the law of civil procedure. David is certified as a specialist in estates and trust law by the Law Society of Ontario. He has extensive experience in litigation at the trial and appeal levels, as well as arbitration. And he regularly speaks and appears in educational events for lawyers, judges, and other professionals, such as today's seminar. He also founded Canada's first student legal aid clinic in elder law at Queen's University. I want to give a big thank you to our sponsors today. We've got Scotia Wealth Management, the B'nai B'rith, Epstein Cole, Concentric Trust, BMO, Private Wealth, TD, Torkin Mains, Solus Trust, as well as Weir Folds. This event is complimentary because of that, so thank you. If you've enjoyed our seminar, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already, and the link for that is in the chat. Okay, I think we may have Alit from B'nai B'rith speaking today. She may have had some trouble logging in. Alit, are you here?
I'm here. I'm so sorry.
Oh, perfect. All right, take it away, Alit.
Rich and I have been doing also these introductions and speaking about B'nai B'rith. So by now, whoever listened and tuned in with us, we've spoken a bit about B'nai B'rith, our advocacy department, and our cares department. For those who do not know me, my name, as you mentioned, is Elite Aronson Manon, and I am the manager of the legal department at B'nai B'rith Canada. B'nai B'rith Canada today is comprised of many different departments: the League of Human Rights, the Committee for Justice in Canada, B'nai B'rith Sports and Community Engagement Programs, as Rich explained last time. B'nai B'rith wide-ranging educational and social programming, committee and volunteer services, and human rights initiative provide a source of connection, continuity, and support to Canada's Jewish community. 2 weeks ago, as I mentioned, Richard Robertson told you all about our cares department, and today I would like to introduce to you B'nai B'rith Sports Department, which is also part of B'nai B'rith community engagement. Since the 1940s, B'nai B'rith Sports brought generations of families together, allowing players of all ages to build friendship, cultivate essential life skills, and give back to the community through engagement and volunteering. B'nai B'rith Sports offers the following sports: softball, basketball, pickleball, which they actually refer to as the kosher pickleball, in several locations across Toronto and Vaughan. B'nai B'rith Sports is about more than winning games. It's a pathway to leadership, personal growth, and community building, all while having fun. Today, we proudly run the North America's largest amateur softball league, and our basketball and pickleball league bring the same spirit of a camaraderie and competition to the winners monthly. And even in times of war and terror, it's important to support members and have fun and have positive and life affirming activities. Thank you.
Thank you very much for that. Okay, we're going to get right into the presentation. David Friedman's going to start us off. Take it away, David.
Thanks very much, Peter. I hope everybody can hear me. I'm not sure you want to see me, but I'm here anyways. Thanks very much for choosing to spend some of your day with us. We have been looking at various issues that within family law that intersect with the law of wills and estates over the last few weeks. And some of the topics that we look at are rather sweeping in scope, and some of the topics are a little bit more refined. This is certainly a more closely defined topic. So the topic that we're looking at it's a technical one, and really has to do with the situation where a person dies with obligations to multiple dependents, and where there's a need to sort out priorities to the proceeds of a policy of life insurance on the life of the deceased. And there's a few statutes that are relevant: the Divorce Act, the Family Law Act, and of course the Succession Law Reform Act. With these seminars, it's hard to know sometimes how to present the material, because there's a lot of people that are attending who practice in various areas of law, some of which deal with the issue on a day-to-day basis that we're looking at any given time, some of which that don't really look at these issues at all in their practice. So my apologies if any of the things that we're presenting upon are bread and butter to you, and you know them quite well, and you're wondering why we're talking about such elementary points. Other people may not be in the same position. So what I'd like to do is I just want to put the issue in a little bit of context, and then turn things over to my colleague James. So the focus of our inquiry today deals with the proceeds of life insurance policies, and generally how the proceeds can be charged for dependent support, or can be used to secure inter vivos Family Law Act, Divorce Act support obligations. And so it's necessary to have at least a little bit of an understanding of insurance. So as you know, insurance is regulated under the Insurance Act. So we have a contract of insurance, and that contract gives rise to proprietary rights. And some of those rights are circumscribed by the provisions of the Insurance Act with respect to how those rights can be managed in an agreement, or how those rights can be made subject of an order by a court, either under the provisions of the Family Law Act or the Divorce Act. And we look at insurance proceeds, or deal with insurance proceeds, all the time in dealing with estate planning. For many people, insurance is the central plank of an estate plan. And so issues to deal with proceeds of life insurance becomes pretty important in terms of estate planning generally. So what we can say then is that the right to designate a beneficiary under a contract of insurance is a property right. It can also, life insurance can also be used in a wide variety of contexts, given that insurance is so flexible and so malleable. So it can be used, and is often used, to secure a simple debt. Mortgage insurance is probably the best example of that. It can be used in terms of commercial succession plans. So what's called key person insurance, where a company will insure the life of a key person, and if that person dies in an untimely way, the business will have insurance proceeds to counter any loss that arises in the interruption of business. And it's also used extensively in family law, both to secure support obligations as well as sometimes to give effect to either a proprietary settlement or settlement of property division, or with respect to the equalization of family law or family property by partners who are separating. And so what we're going to be looking at today is how the law of dependent support and the law respecting the use of insurance proceeds as security for support obligations can be put together in a pragmatic model of law. And the key issue becomes how to manage the irrevocable nature of a beneficiary designation, whether it is agreed to as part of normally a separation agreement or a court order under either the Family Law Act or the Divorce Act, and the availability of the proceeds outside of the scope of the security, either for estate planning purposes generally, or how those proceeds might be available to fund the support of dependents under the provisions of Part 5 of the Succession Law Reform Act. There is a paper that's available. You can download it. I believe there's a link in the chat bar. If we talk about any cases today, I think those cases will in all likelihood be in the paper, the citations. If we discuss anything, any cases and the citations are not there, please just shoot me an email. I'd be happy to send you the site. And having said all of that, let me turn it over to my colleague James Dunphy, who will give us some remarks about dependent support and insurance proceeds generally. Over to you, James.
Great. Thanks very much, David. So again, I'm just going to set up the discussion about proceeds of life or of insurance policies, its intersection with the SLRA, the FLA, the Divorce Act, and just talk a little about dependent support and the clawback provisions in Section 72. So I guess the basic premise of dependent support regime is that if an individual has either a legal or a moral obligation to provide for another person while alive, then he or she must provide for that dependent after death as well, at least to an appropriate extent. And if you go to the Succession Law Reform Act, Section 58 tells you that where a deceased, whether testate or intestate, so whether there's a will or no will, has not made adequate provision for the proper support of his dependents, the court may order that such provision as it considers adequate be made out of the estate of the deceased for the proper support of the dependents or any of them. So who is a dependent? Again, Section 57 of the Succession Law Reform Act tells us that a dependent means a deceased spouse, their parent, child, or the brother and sister of the deceased to whom the deceased was providing support or was under a legal obligation to provide support immediately before his or her death. And for the purposes of the Succession Law Reform Act, a spouse includes a common law or a same-sex partner as well as a married spouse. So what about support? Well, support is not limited to just cash. It can include providing housing, transportation, utilities, food, clothing, education. And there are two very important cases which help to create the modern framework for how dependent support cases are considered. The first is the 1994 Supreme Court decision in Tatarin, sure I have that right, and the 2001 Ontario Court of Appeal decision in Cummings. And what these cases affirm is that not only are legal considerations a relevant factor to consider, but also moral considerations, and this factors into the dependent support analysis. So the test in considering whether or not adequate provision has been made is you look at, first of all, what legal obligations would the deceased have had if the question of the provision of support came up during their lifetime. And then the second question in the test is what moral obligations arise between the deceased and his or her dependents as a result of society's expectations of what a judicious person would do in the circumstances. Now, there's an argument that perhaps the second branch of that test is underutilized in Ontario, but that's a discussion for another day. So, Section 72. This also sits in the Succession Law Reform Act at Section 72. And it also factors into the machinery whereby the courts can provide support or adequate support for dependents. And for the purposes of satisfying a claim, Section 72 permits the court to look to assets that otherwise would pass outside of the estate, that otherwise a dependent would have no right to look to. And it is a powerful piece of legislation. Some of the assets that are set out in Section 72 include insurance policies that have a designated beneficiary and also some jointly held property. So in practical terms, if a court finds that adequate provision for a dependent is, say, $1 million, but there's only $250,000 in an estate, the court is empowered to look to the assets listed in Section 72 to make up the shortfall. And if the only other asset in the is a policy of insurance on the deceased's life, the legislation permits a court to look to that asset to potentially claw it back for the purposes of providing adequate support. And that can lead to some tension, as we'll discuss a little later on. So it's typically said that assets are clawed back into the estate for the purpose of determining an appropriate support award. And you might say, why are assets clawed back at all? Well, as a society, we've determined that if a deceased had sufficient funds at the time of his or her death, then it's the deceased rather than the state that should be responsible for providing the support to the dependent. And there's a more detailed look back at the legislative history of Section 72 and the policy underpinnings in the Court of Appeal decision in Dagg v. Cameron Estate. That's the 2017 ONCA 366 Canley citation. It's well worth a look. So Section 72 has sometimes been called the anti-avoidance provision. And the section can certainly operate to defeat, a deliberate attempt by a deceased to avoid obligations they may have to their dependent. But it can also kick in where a deceased made no attempt to avoid their obligations. A deceased might have said, I acknowledge the existence of a dependent. They might have turned their mind to the provision of support and left an amount that they considered was adequate at the time. It doesn't matter. The court is still empowered to look to the Section 72 assets if the court finds that the amount left was inadequate. And you should always remember that the adequacy of provision for support is determined as at the date of the hearing of the application. It's not when the deceased passes away or the date of the deceased passing. So very helpfully, Section 72 tells you what type of assets are subject to clawback. And I'll run through them very quickly. The first is gifts mortis causa. And these are simply deathbed gifts or gifts made in contemplation of one's imminent death. The next two types of assets are money deposited in the name of the deceased, either in trust or in an account in the name of the deceased and another person. So jointly held assets or assets held in trust. The next category of asset is any disposition of property made by the deceased, where he or she holds the property at their death jointly with another. The next category is an asset which has been or which is subject to an instrument whereby the deceased retains the power to revoke the disposition that would typically arise in the case of a trust. For the purposes of today, any amount payable under a policy of insurance affected on the life of the deceased can be clawed back. However, only if it is owned by the deceased. That's important. Also, any amount payable on the death of the deceased under a policy of group insurance can be clawed back. And finally, Section 72 permits any amount payable under a designation of beneficiary under Part 3 of the Succession or Reform Act. And Part 3 of the Succession or Reform Act captures pensions, retirement, welfare, profit sharing funds, as well as your registered plans, RSPs, RIFs, TFSAs, and even home ownership savings plans. So the list of assets subject to clawback is really broad. And you might hear them referred to as simply Section 72 assets. And it's common for estates litigators, when they're commencing an application for dependent support, to include relief seeking to have Section 72 assets clawed back. And you might wonder whether holding funds or property jointly with a person who may be subject to a future clawback is something to avoid. But fear not, because Section 72(2) says that the extent of the clawback is limited to the funds on deposit that were the property of the deceased immediately before the deposit. Okay, and of course, the burden for proving that the deceased owned the funds lies on the dependent. So we've seen that Section 72 casts a really wide net over the assets of a deceased person. And then it raises the question of whether all assets that are owned by the deceased and subject to Section 72 are subject to that clawback provision. For example, can proceeds of a life insurance policy, which have been earmarked as security for a spousal support or child support obligation, can they be clawed back to ensure adequate support for a dependent? And how does the tension that's apparent between the estates legislation and the family legislation, how is that dealt with by the courts? So, David, perhaps this is a good time to turn the mic over to you, who can speak a little bit more about these issues.
Okay, I was just enjoying listening to you. All right, so I'd like to talk about some of the issues. I am going to refer to some of the statutory provisions and the cases that are in the paper. And so if you have access to it, you might find it helpful to have it at hand. If not, that's fine too. But I'll direct you to where I am. But don't worry, we're not going to have a group reading of the statute out. So I'd like to talk about the use of life insurance in family law, first of all. And I should say I'm not a family law lawyer. So if I say anything that's wrong, feel free in the questions to slug me. But I'll try not to commit too many sins. So life insurance is used quite commonly to secure support obligations, spousal and child support obligations in family law, both under the provisions of the Divorce Act and the Family Law Act. And if you look at model separation agreements that are produced by, the Law Society or the OPA or the commercial publishers, you'll note that normally there's not much in the way of commentary as to how to manage the use of insurance proceeds as a form of security. Where insurance proceeds are used as security in commercial transactions, there's a lot of time that's spent on determining what the nature of the obligation is at any time and what form and what the extent of the security that's required is, and how that security might be released as the obligation, as the debt goes down. But unfortunately, that hasn't really been the case as I understand it in family law practice, which more or less gives rise to the kinds of issues that we're talking about today. So the provisions of the statutes that give the court jurisdiction to make orders are set out in the paper. on pages 2 and 3. These are sections 15.1 and 15.2 of the Divorce Act, and section 33 and 34 of the Family Law Act. And I'm not going to deal with questions about whether the court has the jurisdiction to order a person that doesn't have insurance to obtain insurance. The statute is, really worded generally in terms of the court's jurisdiction, and to a certain extent in terms of designation of beneficiary in respect of existing life insurance policies. But I think that we can say that in general terms, courts do make orders for people to obtain life insurance and to designate irrevocably a beneficiary, the payee, in respect to as a form of support. In the paper, I've tried to highlight on pages 3 and 4 and 5 that this is a discretionary decision for the court. So there's not an entitlement to have insurance proceeds be used to secure support. If the matter is to be decided by the court, then there's a discretionary decision as to whether the security is to be is appropriate or not appropriate, and then what form of security the court should order. And so when exercising its jurisdiction, the court is going to look at, is there a risk that the support payor is actually not going to fulfill their obligation? And we can look at whether they've committed an act of bankruptcy or whether they failed to adhere to the obligations under existing support orders, or any other factor that goes to highlighting the need for security. If there isn't security, then the payee on the death of the payor really can only rely on the support obligation being the first charge on the estate. And in that case, unfortunately, the payee will have to compete with other creditors for the assets of the estate. And having a form of security obviously obviates that, and is certainly something that family law practitioners are alive to, and therefore we have separation agreements or model court orders that commonly include provisions for life insurance proceeds to be used as a form of support. So as I said previously, the linchpin for all of this is the provisions of the Insurance Act with respect to the irrevocable nature of a beneficiary designation. And so in the paper on page 4, we set out section 191 of the Insurance Act, which is the complicating factor in all of this. So the Insurance Act provides that life insurance proceeds can be designated irrevocably, which means that in order to change the beneficiary designation, the consent of the beneficiary is going to have to be obtained, or a court order waiving or deeming consent to have being given. And so this is an important provision because the court has a limited jurisdiction to relieve against this. Where there is an irrevocable designation, that means that absent the order of the court or the consent of the beneficiary, it's not going to be possible for the owner of the life insurance policy just to redesignate the proceeds in favor of someone else. Obviously, they could choose to terminate the contract of insurance and obtain a new policy of insurance. But there's a problem realistically with that. And this often occurs with respect to separations and divorces later in life or later life relationships. And that is that the payor spouse may no longer qualify for life insurance. And so it's important then to be able to deal with the life insurance policy that's in place and whether the beneficiary designation can be managed, notwithstanding the fact that it's been made irrevocably. That's to say that, and this is where these cases often arise, is that there's a competition between dependents from a first marriage with dependents from a second marriage, and the payor spouse at the time of the second marriage is either too old or has health issues that realistically prevent him or her from obtaining a new policy of life insurance in favor of the second family. And that's why this question of how to manage an irrevocable designation and releasing proceeds that are no longer needed as a form of support for support obligations in respect of a first family to be able to estate plan in favor of a second family. That's why these issues become important. And so again, Section 191 of the Insurance Act is the section that really becomes quite important in all of this. So James took us through the statute. And so the difficulty that arises then is that where you have life insurance that's been used to secure a family law act or a divorce act or a separation agreement obligation of support irrevocably, and the payor spouse dies with other dependents who now bring a dependent support claim, both sets of dependents are going to look to the same policy, the same proceeds of life insurance to be able to fund their support claims. The first family will be looking at the separation agreement or the Family Law Act or the Divorce Act order. The second family will be looking at the dependent support provisions of the Succession Law Reform Act, and particularly Section 72 sub 1 sub F and sub F.1, which are the two provisions that say that life insurance proceeds can be brought back into an estate for the purposes of dependent support, not for the purposes of paying general creditors, not for the purposes of funding testamentary gifts, only for the purposes of dependent support. And so then the question becomes, how do you manage these two competing regimes? So there is a section in the Succession Law Reform Act that becomes important, and this is Section 72 sub 7. And Section 72 sub 7 is set out in the paper on page 8. And it's a curious section. In the paper, tried to trace its origin. These provisions of the statute in respect of Section 72 made their way into our statute in the first really major overhaul. Dependent support came into Ontario law in 1929. There was a bit of an overhaul in the late 50s, and then there was a major overhaul in 1977 at the same time as the Family Law Act was reformed. And as you may know, there was a multi-year Ontario Law Reform Commission reform process that led to what now is the Family Law Act and its provisions, as well as dealt with the dependent support regime to a certain extent, and that folded into Section 72 of the present statute. So what there is this section that seems to deal with this, Section 72 sub 7, and again, as I said, this is set out on page 8 of the paper, and it's a brief section, so I'll just read it out. This section, that is Section 72 sub 1, the clawback provisions, does not affect the rights of creditors of the deceased in any transaction with respect to which a creditor has rights. So this means that in respect of those assets that normally flow outside of the estate but are brought back into the estate for support purposes, we recognize that third-party creditors may have legitimate interests in those assets, and their claims should not be defeated. And that can be any number of the transactions that are caught by Section 72 sub 1, whether it's a gift DMC, or whether it's a joint bank account, or whether it's a policy of life insurance on the life of the deceased. The first case that dealt with this is Dagan Cameron Estate, which is a 2017 judgment of the Court of Appeal, as James said, and is dealt with a bit in the paper. And this is an important case in respect of this particular section. It's the first case that deals with section 72 sub 7, but it was a case, and this issue is a practical issue, obviously. I would highlight the importance of the judgment in the sense that the Court of Appeal agreed to hear the appeal, notwithstanding the fact that it was moot at the time the parties had settled. And so the Court of Appeal acquiesced to the invitation of the parties to hear the appeal. And I think that the fact that the late Phil Epstein was acting as lead counsel for the appellants was very helpful in the court agreeing to hear this case at all. I think that Mr. Epstein, obviously his reputation and his knowledge of the law and his influence with the court was quite decisive. And so, just for those, because we're dealing with the intersection of family law and estates law, I think it's worthwhile to highlight the influence, the importance of Mr. Epstein on the evolution of family law in Ontario and the role that he played in this particular appeal. So Dagan Cameron Estate dealt with a really simple situation, prototypical for this issue. You had a couple separate with minor children, and divorce proceedings commenced. And there was an order made on an interim basis that obligated the husband to irrevocably designate the wife in respect of an interim consent order mandating support. That support obligation was later made subject of another consent final order. So that support obligation was tacked down, and that irrevocable beneficiary designation provision was tacked down in that final order. The husband had meanwhile gone on to repartner in a cohabitational relationship. His partner was pregnant, and then, a very sad case. Unfortunately, this fellow began to feel ill, went to the hospital. They told him that he had stage 4 lung cancer, and he died three weeks later. And so he left his first family, separated and not yet divorced wife and the 2 minor children, with his new partner, who with a child in utero at the time. And the question then became how to fund the support obligations that he owed towards these 2 families. And it turned out that the only asset that he really had was a policy of life insurance through his work, which yielded $1 million in proceeds. And so the question became, is the policy going to be caught by section 72(1)(f), or is the policy excluded on the basis of section 72 sub 7 of the statute, giving the first family priority? And so the case made its way up through the family court and trial and the divisional court as first appeal, because it's a curious fact that the Dependent Support Act that appeals first go to the divisional court, and then if there's leave given, second appeal is available to the Court of Appeal. And any case went forward, and then the court looked at how to be able to look at this section 72 sub 7 to determine how this issue should be resolved. In the paper on page 10, 2 paragraphs of the Court of Appeal judgment are set out. And this is a judgment of Mr. Justice Brown. And I just want to read out, I'm sorry, I don't usually like to read out paragraphs of judgments for obvious reasons, but I'd just like to read out one paragraph and just explain how the issue is resolved. So this is paragraph 77 of the judgment in Cameron Estate and Dag. And again, it's on page 10 of the paper. And this is what Justice Brown says in explaining how section 72 sub 7 should be understood. Where such a beneficiary designation order is made ancillary to a child or spousal or child support order, the support recipient is a creditor of the deceased in a transaction with respect to which the creditor has rights. What does that mean? It means that the support payee is a creditor with respect to the support obligation, which brings that support payee into section 72 sub 7, and then dealing with the policy becomes a transaction which is dealt with again by section 72 sub 7. So Justice Brown goes on to say, the transaction, that is the transaction under section 72 sub 7, is the purchase or maintenance by the deceased of a policy of life insurance on his life, which stands available by operation of court orders to satisfy the deceased spousal or child support obligations on his death by designating the support recipient as the beneficiary of the policy. So once you have a support order that identifies the use of insurance to secure an obligation, that's what brings you now into section 72 sub 7, which will elevate the priority to the policy in favor of the first family by virtue of that order and section 72 sub 7. So in other words, those proceeds will not, in whole or in part, will not be clawed back by section 72 1F in favor of the second family. And so just to finish off the paragraph, Justice Brown goes on to say, for the purposes of section 72 sub 7, the support recipient is a creditor of the deceased because, as the court ordered designated beneficiary under the policy of insurance, the support recipient has the legal right to look to the policy's proceeds to satisfy the deceased support obligations calculated at the time of death. Those obligations can include any existing arrears, and 2, the present value of any future support obligations calculated by reference to the terms and duration of the support order in place at the time of the death. In other words, then, importantly, it's not just future support obligations that are going to fall within section 72 sub 7. Arrears in respect of existing court support obligations at the time of death will be caught. And now we have to determine what value in those proceeds we look to the nature of the support obligation that was ordered. And this is where everything falls apart. Because normally, as a matter of practice, and correct me if I'm wrong, those of you that are practicing exclusively in family law, there's not a lot of attention that is being paid to the support obligation, especially when it's in favor of a spouse, and there's a lifetime support obligation or a longer term support obligation, as opposed to a conventional obligation that is owed to just children, payable in respect of income, as well as section 7 expenses. And so what if this was in a commercial context, the parties are going to bargain as to the nature of the security that's required to secure a debt. When it comes to looking at the security provisions of an order to secure support, oftentimes not a lot of attention is being paid to that, because no one is really considering untimely death other than the availability of these proceeds. The difficulty, of course, as I said, is that we want the proceeds to be available not only to the first family, but we'd like the proceeds to be available when they're not going to be used as security for support for the second family, as not just as to secure support obligations, but to allow for estate planning. And so we don't want to have a windfall to the first family where there's just an irrevocable designation and there's nothing more that controls as to the nature of that obligation. So how do you go about managing this? And that's really the task. And in the paper, there's a couple of ways that you can go about managing this. The first is just in a domestic agreement, or in the order itself, I suppose, if it's on the basis of support, or insisting that the trial court deal with this question in a judgment. How can we build into the security obligation basically an elevator, so that as the support obligation diminishes, the part of the policy that's no longer needed could be made available for other purposes? And there's a Court of Appeal case on this point that's important, and that case is called Katz and Katz, and that is the reference is set out at page 12 of the paper. This is 2014 ONCA 606, a judgment of the Court of Appeal. And again, I don't want to read extensively from judgments, but I do want to highlight some of the dicta in the judgment written by Madam Justice Simmons. And again, this is page 12 of the paper, paragraph 74 of the judgment. And I just want to read out a couple of sentences. Careful consideration should be given to the amount of insurance that's appropriate for security rather. It should not exceed the total amount of support likely to be payable over the duration of the support award. Moreover, the required insurance should generally be somewhat less than the total support anticipated, where the court determines that the recipient will be able to invest the proceeds of the insurance payout. Further, the amount of insurance to be maintained should decline over time as the total amount of support payable over the duration of the award diminishes. The obligation to maintain insurance should end when the support obligation ceases, and provision should be made to allow the payor spouse to deal with the policy at that time. So this dicta was directed to courts that are making orders that oblige the payor spouse to designate irrevocably the payee to secure a support order. And so that 2014 judgment of the Court of Appeal in Katz really becomes very important when you tie it together with Section 72(1)(f) of the Succession Law Reform Act. The Dagan-Cameron estate case is pretty representative in the sense that all you really had was parties agreeing to a consent order, basically, a separation agreement, with a provision for life insurance to be used as security, but it doesn't say very much, or life insurance to be designated, but it doesn't say what the purposes are. Is this part of property settlement? Is this security? Like, what is it? And so what Katz and Katz highlights is we should be building into either consent court orders or agreements how we're going to calculate at any given time what the support obligation is and what the matching security is, so that the excess of the proceeds can be then used for other purposes. And if you don't do that, unfortunately, it may be the case that the court can't discern the intention of the parties, or doesn't have a jurisdiction to alter things, or that one party gets a windfall and one party and the second family gets nothing, which is obviously, I don't think, what anybody would consider to be a pleasing result. So you can manage this question in a separation agreement.
Sounds like you may need actuarial advice, David.
Yeah, I mean, you could. It may be that that actuarial tables are going to assist. It may be that the parties can just create a process for being able to determine at a given time, and therefore, we can have some specificity as to what portion of the policy can be excluded.
Right.
The last thing is another point that was mentioned in the Dagan-Cameron estate case, which is another way of dealing with this, which is, to my mind, not as attractive, but it's there. And that is to change the ownership of the policy. Section 72(1)(f) talks about certain kinds of transactions being clawed back, one of which is insurance proceeds on the life of the deceased, but only where the policy of insurance is either owned by the deceased conventionally or as a group life insurance policy to which the deceased has exclusive control over the beneficiary designation. And so you can have an insurance trust. And so that's all good, but every time you put into play a trust, you have to make sure that it's drafted properly and that you anticipate that there might be opportunities for mischief or opportunities where there's bad behavior for the court to be involved, such as removal of trustees or, or other problems that, in trust practice. And I don't think we need to go there. Everybody knows the problems that can arise in respect of trust. So for family practitioners, if it's considered that it's appropriate to move ownership of the life insurance policy from the support payor to a trustee, I would very much encourage family law practitioners to have the client retain somebody that regularly deals with testamentary trusts, and to ensure that the trust is properly drafted, because it may yield a whole host of other problems that are equally as bad as the problems that you're trying to avoid. But it certainly is a strategy that can be usefully employed to avoid having to deal with a policy in Section 72(1)(f). And having drawn on for a very long time, I don't know how much time there's left for questions. My apologies.
That's all right, David. Valuable information. Is there anything else you wanted to add, or should I open the floor to questions?
Brown envelopes full of cash can be sent to me courtesy of Wagner Sidlowski.
All right, well, again, thank you both very much for it. We do have a few minutes for questions. I see that there's a couple in the chat, so I'll start with those. This one's a probate question. Let's say there is a clawback of these Section 72 assets. The question is, are those assets then subject to probate fees?
No. So those assets are going to be clawed back into the estate by virtue of the court order for dependent support, and essentially those are going to be paid directly to the dependent, and are never really estate assets. All they are notional assets, and this is the point that it's actually right in Section 72, is they are notionally part of the estate. They're not truly part of the estate, because if they were, they can then be attached by third-party creditors.
So maybe I can push that into the second question that we have here. There's often, let's say a deceased or the spouse of a deceased gets nothing under a will, and they've got sort of two options that they're looking at: dependent support or an election under the Family Law Act. The question here is really more of a strategy. Is it more risky from a litigation perspective to go ahead and pursue those Section 72 assets in dependent support, or does it make more sense to go ahead and seek an election under the Family Law Act with respect to the estate assets? I mean, my opinion onto that is it's a very contextual question. I think it would very much depend on the value of those Section 72 assets, among other considerations, but happy to see what you two think.
Yeah, it depends on the value of the assets. If the value of the Section 72 assets is enormous, then I'm going after the Section 72 assets. But interesting to hear how you would approach it, David.
You give me two claims, I'm taking both of them. So, the equalization claim deals with a right to property. The dependent support claim deals with a right to support. And so the equalization claim deals with the static value of the estate and how much of that value properly belongs to the surviving spouse. The support obligation looks into the future. And so now the question becomes, should those other assets be brought back notionally into the estate for the purposes of that support? But, this is whenever you get into these areas, you do really have to check the title to assets. Like if you're going to make an equalization claim and you bring asset back in, or you destroy, an estate planning technique, bear in mind that there might be tax that arises depending on how things play out, and it may be that those elections are regretted after the fact. And so I agree with my colleagues that it really is a question of the particulars of a given situation, and which would control the advice that you're giving.
Some important limitation period differences between those two claims as well. So it's good to be on top of that. All right, we've got another question here. Have you come across a case where the second partner is named a beneficiary to the life insurance, and the still married spouse is left with nothing?
All the time.
So the question, I guess, is it's a bit unclear. Is this a case with respect to an intestacy? Not sure if the person who asked that question wants to speak on Zoom to sort of clarify what they were trying to ask. Feel free to do that. Otherwise, might move on. Oh, I see. Ms. Sang, are you there? Did you want to ask the question?
Yes. So the situation is the person died intestate, so there's no will. And outside of the pension, there's nothing except for life insurance. And life insurance is employer sponsored. So and the beneficiary was changed from first spouse to the new, the person may or may not qualify as a partner yet, but they changed the designation to another person. So the spouse, who's still married at the time of the death of the disease, is left with, there's nothing else, and there's only the life insurance that we could ask for the court to revoke the designation. I don't know if that's, like clawback would be the entirety of the I guess the policy. Because of it.
I think that's exactly what Section 72(1)(f) is all about. Is you have a circumstance where you have a separation, so that now separation is going to, depending when it took place, we now know that party may lose their inheritance rights, but still have a right to equalization. But if there's nothing in the estate, there's nothing in the estate. If the deceased partner has designated those life insurance proceeds in favor of someone else, probably a second spouse, and the policy was owned by that person, then that certainly could be clawed back. And that's the whole point of Section 72(1)(f), is to prevent avoidance of that support obligation that's owed to the first family in favor of someone else.
Okay. So the separation took place before January 1st, 2022.
Okay. Well, in this case, it doesn't sound like there's anything in the estate anyway. So, talking about equalization is not really going to go anywhere, because there's nothing to equalize, right? There's no asset, there's no property that's available. So the fact that there's a dependent support claim, you do have a limitations issue, depending on when the claim is being brought. But in principle, the insurance proceeds are still chargeable for the support of the separated spouse.
But it cannot be considered as part of the estate. There's no way that we could get it in as part of the estate.
No, and as the other question highlighted, if you were successful, you might lose part of it in the state administration tax.
Right. Okay.
All right. I see that it's sorry about that. I see that it's 1:04 p.m. I know everyone's busy, and we've promised you that this will stop after an hour. So I'll hold me to that promise, and we'll end it now. Just for, concluding remarks, again, thank you for everybody who attending. We're gonna have a bit of a break until our next seminar. We're gonna give you some time to take a nice vacation over the summer. On September 17th, 2024, we're gonna resume with a seminar on an overview of the equalization election. That's gonna be chaired by Brad Phillips, as well as of our firm, as well as Aaron Betts and Alyssa Weinerman of Epstein Cole. If you haven't registered for that program yet, you can do so at the link posted in the Zoom chat. Also, make sure you download the paper and the certificate of attendance before you log off. As a final reminder as well, the link to the B'nai B'rith Canada Food Program can also be found in the chat, and we ask that you consider making a donation to that. Thank you again for everybody who attended. Thank you to James and David for presenting today. Really helpful, difficult topic, and we appreciate the insight in the paper. That's it, everyone. Have a great afternoon.